Welcome to today's program titled Time Well Spent Session 7, Compensable Work Time. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during the webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Kelly Kelker. Kelly, please go ahead.
Thank you, Donna. Good afternoon or good morning, everyone, wherever you may be. Thank you for joining us today for our final session of the webinar series, Time Well Spent. Those of you who have joined us for previous sessions, I've heard this before, but my name is Kelly Kelker, and I'm a member of Seyfarth's Atlanta Wage Hour team. We designed this series in recognition of the fact that 10 years have passed since the initial publication of the treatise Wage and Hour Collective and Class Actions that's published by Law Journal Press. And the editors-in-chief of that are three partners in our Wage Hour team, Brett Bartlett in Atlanta, Noah Finkel in Chicago, and Andrew Paley in Los Angeles. And one of my duties is to update the treatise twice a year to keep it current in light of all the developments over the past 10 years. As in prior sessions, my role is simply to keep things moving along here, to start things off and make sure we cover in the next 45 minutes one of the most foundational issues in wage hour law, which is what constitutes time for which employees must be paid. It sounds like a simple question, but for those of you who might have security check requirements or employees who work at home part or all of the time, it's not as easy as it sounds. We're fortunate today to have with us two partners in our Wage Hour team to discuss what courts have been saying about compensable work time. On the federal issues, you'll hear from John Phillips, a partner in our Houston office, and I'm sure you'll join with me in wishing John and the entire city of Houston good wishes as they recover from Hurricane Beryl. We're glad you're up and running and be able to be with us today, John. John has extensive experience defending complex wage hour actions and also has experience in discrimination and traditional labor matters. John's industry focuses include transportation and logistics, manufacturing, chemical, and financial sectors. Discussing California issues will be Michael Afar, a partner in our Los Angeles Century City office. And Michael is pretty much a walking encyclopedia of those issues, in particular litigation under PAGA, California's Private Attorneys General Act. Michael manages complex class actions and PAGA matters under California law, and he has methodically developed all of the skills you need to defend them, from discovery and investigation to briefing and to the courtroom skills that he has used in jury trials of these matters. He has particular experience partnering with clients in industries such as hospitality, retail, and transportation. And with that, John, can you please kick us off?
Thanks so much, Kelly, and thanks for the kind words. Also, hard to believe that it's been 10 years since the book came out. Yeah, so here's the agenda of what we wanted to cover today. We want to spend a little bit of time going over some of the background issues about what is work under both the FLSA and under various state laws, and then talk about what pre-shift and post-shift activities must be compensated, deal with some meal and rest break issues, some off hours type work issues, and some couple of special defenses. So if we could go to the next slide, please. And one more. So just some what does it mean to work in general? You know, it's some activities are easy to identify. You know, if somebody is actively on a production line somewhere doing work, clearly that person's working. But then it gets much harder, and we'll go over some of those issues. Michael, anything you want to add to this slide?
Yeah, just first of all, thank you everybody for joining. It's always nice to see some familiar names, maybe not faces yet, but names at least on the attendee list. And we certainly appreciate that you're joining us on this last session and to the extent you've been with us for the prior sessions as well. You know, compensable time is always a tricky subject. It seems so obvious to folks, and yet we still seem to be dealing with these same issues year after year. And, you know, no matter what cases come out and what clarity or lack of clarity we get, the lines always continue to be blurred as to, you know, are we paying for every minute or second that an employee is working? What other tasks are popping up? I think everybody generally will be able to identify the activities that are traditionally work. You know, you hire somebody to work on a line in a manufacturing facility, for example. When they're working on it, that's clearly work. But what do you do with some of these examples that we've put up on the screen for boot up time or security checks or traveling to different job sites, donning and doffing? What other types of factual situations might pop up where it's not necessarily a clear cut, this absolutely has to be compensable? So we'll do our best to cover a lot of that and get into the contours of the law and give you a little bit of a primer in the 45 minutes that we have here today.
So if we could go to the next slide. So generally, there's going to be federal and state law that governs whether a certain activity is work and must be compensated. Under the FLSA, under the Fair Labor Standards Act, the federal law, there's been a couple of different changes over the years. So originally, when the FLSA was passed, the Supreme Court defined work as all time during which an employee is necessarily required to be on the employer's premises, which was very, very broad. And it prompted a almost, very quickly change to the law from Congress in the form of the Portal to Portal Act, which has been updated a few times over the years. But generally, it exempts a couple of things from work, from that broad definition that the Supreme Court came down with, and it carves out two exceptions. One, walking, riding, or traveling to and from the actual place of performance of the principal activity or activities for which the employee is employed to perform. So if you're, walking to an assembly line, for example, that could be non-compensable time under the Portal to Portal Act. And then also it exempts activities which are preliminary or post-liminary to the employee's principal activity or activities. And then building off of that, we also have the continuous workday rule, which generally states that once an employee begins performing one of their principal activities, their day is compensable until they finish their workday. And there's various exceptions to both of these rules that we'll go through later today, but those are some of the main points under the federal law. And Michael, do you want to state law?
Yeah, absolutely. Not to be outdone, California, as always, has its own particularities and peculiarities. Shout out to our CalPEX publication. And, in California, for example, we have two separate ways that time is considered compensable. One is if an employee is subject to the control of the employer, and the other is to the extent an employee is suffered or permitted to work, whether required to do so or not. And those are mutually exclusive. So you can have activities that fall into one or fall into the other, and both would give rise to compensable time. And we'll talk about some of the cases later on, about what the tests are, what the factors are that courts will look at to see if this is an activity that's required by the employer, if it's something that would render itself to be subject to the control of the employer or not. And unfortunately, a lot of those tests are a heavy factual inquiry. And so a lot of the common theme that you will hear here today is that a lot of this will be required to kind of dig into the facts of what's going on in your situation. There's not necessarily going to be a clear line or a bright line rule or case that could potentially apply. And that makes it tricky to, one, prepare for these types of claims, but also to defend them if it comes up in some sort of litigation. Next slide, please.
And one more, if you would. So generally, just some different types of common work or non-work, as the case may be that comes up. So when you're talking about travel and commuting time under the FLSA, generally speaking, home to work travel is not compensable, although it can get, as facts are more murky, it can get tricky. So for example, there was a decision out of the Fifth Circuit recently where the employer had a construction site where the employees were working, but the way that it was configured, they could only get there by certain buses that the employer required all the workers to get on and then travel to the work site. And so the employees would have to drive to a particular parking lot, load up onto a bus, and then go to the work site to start work. And the employer treated that time on the bus as non-compensable home to work travel. And that was challenged in a FLSA case, went up to the Fifth Circuit, which found that time was not compensable because it was similar to home to work travel, even though it was a requirement of the employer that the employees take those buses. So the facts can get tricky, and you have to dig into each one. But that's an example of even a somewhat tricky facts where it was found to be not compensable work. Another general rule is travel on employer's premises. Again, it depends on the facts. It would be non-compensable typically if it's done before principal activity is started. If it's done after an employee starts doing principal activity, then it would be compensable time. So you'll see here another example of an 11th Circuit decision where the court found that time spent riding buses from employees' parking lot to the security gate, going through the security itself, and then riding different vehicles to the work sites was not compensable work because all of it was done before any principal activities were started by the employees. And then conversely, if you have travel between work sites, that it will be compensable time. So once the employees started their principal activities, you have to pay them for all the time after that, including if they're going from work site to work site. Next slide, please. And a few more that get a little more difficult. Where if you have, for example, a situation where an employee is performing some principal activities at home and then they commute to the work site. For example, they may be checking emails at home and then driving into the office. They may be coming home and then sending in reports and different data. And those cases are much harder and are really going to turn on the facts of the particular case. There have been a few decisions, one out of the Ninth Circuit, and I believe one out of the Second Circuit, where the courts found that a small amount of time in the morning before commute or in the evening after one was non-compensable time. In those situations, the employee had flexibility to do their own activities. They could use time for their own purposes. And the court found that just because they were sending an email in the morning or logging into a system in the morning briefly, and then in the evening, it didn't mean that their whole entire day had to be paid from the beginning until the end. But those cases will be harder and much more fact specific. Another point is use of company vehicles. It doesn't automatically create working time just because you have an employee who's driving a company vehicle. Or even if that company, the employee can only drive that company vehicle for certain, maybe from home and to the to work, but they can't do any personal errands in a company vehicle. The Congress actually amended the Portal to Portal Act back in 96 to address the employee commuting. So there's some specific requirements around those. And then generally activities incidental to the use of a vehicle doesn't make that become part of the employee's principal activities, like filling up, gas and things like that. Next slide, please.
Thanks, John. So one of the things that we're also seeing pop up in California, of course, is the issue of the commute time. This is actually a case that started out of the Ninth Circuit and was certified to the California Supreme Court to address the question under a particular wage order, but a lot of the concepts still apply to employers in a lot of different industries as to whether time spent waiting on an employer's premises, going through, effectively like a parking check, getting in through a gate, going and parking, eventually making your way to the work site, what portions of that time, if anything, are compensable or not compensable? And in doing that, they're looking at a lot of those same factors of what is typically constituting control. And so in this California Supreme Court decision, which came out earlier this year, the ultimate ruling was that if you have time spent on an employer's premises in a personal vehicle and you're waiting to scan your identification badge, that is going to be deemed compensable time. But on the flip side, if you are on the premises in your own vehicle, you're driving between that security gate and a parking lot, that generally is not going to be compensable. And there's a lot of factual underpinnings as to why the court ruled in that way. But it's, again, another thing to think about if you have employees in these particular situations, if this is something that could potentially be applicable to your business, to look at what you have, how much time potentially is being spent. If you have a lot of time that these employers are waiting, is it your parking or security gate? Is it some third party? There's a lot of factual inquiries that go into that we would suggest that you look at. If you have questions, of course, you can reach out to your favorite Seyfarth lawyer and we can help with it. But it's one of those things that's important because I think a lot of folks just traditionally would not expect anything coming up into your work site or just getting onto the premises might be or could potentially be deemed as compensable. And as we continue to see in California, these issues are bubbling up to the top. They're reaching the attention of the California Supreme Court, and we want to make sure that everyone's aware that there could even be small amounts of time that are potentially compensable. Next slide, please.
Yeah, real quick, Michael, to piggyback off of that. I mean, it does drive home the point, just the difference that, state law obviously makes, right? So just generally under the FLSA, you would expect that none of that time would be compensable. So that was just the only point I wanted to make there.
Our favorite California state. So the other areas that we're seeing with potential compensable time are these other activities where people are preparing for work, doing things before work or after work. There's three general areas that we wanted to flag. One is hopefully not happening anymore. It's kind of faded out, but we're still within the potential statute of limitations for these types of claims. And so that's the COVID screenings. But more importantly and more regularly that we're seeing are still security checks of some sort, whether that's in the retail context through bag checks or bodily inspections to make sure people aren't taking merchandise, or also some sort of security check to enter into a secure facility or things like that. The other areas are with boot up time, which is popping up more and more, and then finally with donning and doffing. So as it relates at least to the COVID screenings and security checks, the biggest decision that came out, it's been over 4 years now, but it was a decision from the Supreme Court in Frelican, which basically said that the federal de minimis doctrine does not apply, which said that these types of activities can be deemed compensable if you are subject to control of the employer, and that's backing off of a prior decision in Troster, which said that there is no federal de minimis rule that applies in California, and so even these small amounts of time could be compensable depending on what it is and whether it's for the benefit of the employer. The COVID screenings, from the case law that we've seen, unfortunately, courts are not really willing to make that kind of initial determination as to oh, it's only taking a few seconds, and so you can disregard that. They've generally held that those types of activities are going to be more and more like a factual inquiry, and you've got to look at how much time is it. Are there other things that need to be looked into to determine whether the employer is exercising some sort of control? There was a case in 2022 in the Eastern District of California where the court refused to dismiss claims for unpaid wages because of the COVID screenings. And, it basically just got to a point where it said the plaintiffs have alleged that it's compensable time. They've plausibly and sufficiently alleged that. And so we're not going to just dismiss it outright. We are going to consider that time to be compensable, at least as alleged. But other than that, there's not really much that's coming out in the way of published or citable decisions. In my experience, a lot of these cases, just because of the small value of time, they're being quickly settled out. And so you're not seeing it, but it makes it harder from a defense perspective to get that kind of case law that you otherwise might want to defend the claims. With respect to security checks and things like that, bag checks were a very hot topic for a long time. I think a lot of employers have generally cut that out, but it still is one of those things where you're looking at courts that are not really willing to make that summary judgment type decision and saying that the length of time to undergo these security checks is so small or infrequent that it would fall under a de minimis test, either under the federal side or under the state side. Definitely less likely under the state side because of the recent case law. When it comes to boot up time, the most recent case is this Cadena case from the Ninth Circuit in 2022, which held that boot up time is compensable time because it's an integral, at least under the FLSA, because it's an integral and indispensable part of their job duties. Coincidentally, just yesterday, the second part of that appellate proceeding, that decision was released, probably because they knew we were going to talk about it today. And it basically said that in that one, there was a tribal issue, at least as to the federal de minimis rule, as to whether the amount of time was compensable or not. There was evidence that the boot up time sometimes took between 5 and 30 minutes, which I know sounds crazy, and that's a whole another presentation we can do on how to get the type of evidence that you need to defend those types of claims. But basically, there was evidence there that the amount of time could potentially be more than the general 10-minute rule that's allowed under the federal de minimis doctrine. And so there was a reversal of that summary judgment win, again, in that case. So even though these are issues that we've seen over the years, it's still coming up to the surface. We're still seeing new developments in the law as it relates to these types of daily activities, both before work, leading up to work, but also after work, to the extent some of this falls off after they clock out. And then, so John, you want to talk about the donning and doffing?
Yeah, I'll talk about donning and doffing briefly. So there's not a couple of circuits have slightly different tests, but generally speaking, whether donning, some type of clothing or protective equipment is compensable under the FLSA, or taking it off, doffing it, the courts look at, one, is it required by the employer? Is it necessary to the principal work being performed by the employee? And is it primarily for the benefit of the employer? And so, courts have found that PPE and different types of equipment required for, dangerous work environments is required to be compensated when the employees are donning and doffing them. But those are the general factors that courts are going to look at to determine that. If the PPE or other clothing or equipment can be put on at home or taken off at home, like steel-toe boots, for example, it's unlikely to be compensable time. More likely, it's non-compensable time. And then there's also a specific provision in the FLSA relating to collective bargaining agreements, which exempts out time putting donning and doffing if it's customary practice, and if you have a collective bargaining agreement that covers it. And so if you do have a collective bargaining agreement, there can be more flexibility in making donning and doffing time non-compensable as opposed to compensable work time. Next slide. So next we wanted to shift into meal and rest breaks, both under federal law and then under state law, specifically California mostly. But so under federal law, the FLSA doesn't require employers to provide meal or rest breaks. Most employers do. Many states do have that requirement, but it's not actually an FLSA requirement. Shorter breaks, what the DOL says is anywhere from 5 to 20 minutes. They deem to be compensable work time. And so even if the employee is completely relieved from work, those shorter breaks need to be paid. For longer breaks, meal breaks in particular, the DOL takes the position that if it's 30 minutes or more, and the employee is completely relieved from duty during that time, it can be non-compensable work, and it doesn't have to be paid. And that can be the case even if the employee is required to stay on the premises. But there are certain situations that courts look at to see whether the employee is actually completely relieved from duty during that meal break, and whether it's what they call a bona fide meal break or not. So they'll look at the limitations that the employer is placing on the employee during that meal break, whether those restrictions are benefiting the employer or not. The duties for which the employee is responsible during meal breaks. So, generally you want the employee to be completely relieved from doing any duty during a meal break to make sure there's no question. And then also the frequency with which a meal break is interrupted, and whether the employee is allowed to resume their break after an interrupted break. So those are some of the factors that courts will look at. Next slide.
Yeah, and so California is going to track it in a lot of similar ways. Obviously, California has a specific requirement where employees have to be provided with a meal period for every 5 hours they worked. There are particular rules as to the timing of that break, what constitutes a quote-unquote late break, or an uninterrupted break or a duty-free break, things like that. It has to be taken before the end of the 5th hour of work. And as John mentioned, traditionally people don't think about meal or rest breaks in a sense of compensable time. Meal and rest break claims are still extremely hot in California, mostly just from a violation standpoint, but it's important to remember the compensability considerations that could arise. We generally don't see people that, to the extent they're taking a short meal break, where it goes from being 30 minutes down to below 20 minutes, but it's very possible that something like that could happen. And then you're not just dealing with a meal period violation, but you're dealing potentially with a situation where that time is not long enough that it would trigger an unpaid break requirement. That's one of the issues. The other issue is, again, with the interruptions. You're going to have a lot of claims in California that employees are interrupted through a radio or a walkie-talkie, or a manager coming to ask them a question, or they run into a guest on their way to take their breaks. There are a lot of factual ways that these types of situations can occur that could result even in small amounts of potential time off the clock. And so while we traditionally view meal and rest breaks as their own distinct category, it's always important to remember the compensability factor that could be in play here as well. One of the things, just as a refresher, not quite as relevant to compensable time, but things to consider for best practices for meal and rest periods. We're looking at waiver options for meal periods. That's also an issue that's on appeal right now as to whether there can be a prospective, effectively a blanket waiver where an employee says, I'm always going to waive my meal periods that fall between the 5th and 6th hour of work, if that's the length of my shift. For rest breaks, you want to make sure that they have the ability to leave the premises. There's been some recent case law developments in that area. Best practices, to the extent you are ultimately looking at revamping or bettering your meal and rest break practices, is to have an attestation system. And again, that's a whole separate discussion that we can have, but it's one of those things that as soon as you can implement it, it will help with defense of any potential litigation you have, but also to just make sure that you are being as compliant with the law as you can. Not to stray too far away from compensable time, but we're even seeing in California with the passage of the recent PAGA reform bill that courts are going to start looking at the practices that clients are implementing or that employers are implementing to make sure that they are trying their best or doing everything that they can to comply, and how that factors into the level of penalties or culpability that should be assessed when dealing with even just a PAGA case in California.
And
what we're also seeing with other states, we certainly won't cover all of them, but I think it's about 50% of all the states have some sort of meal or rest break requirements, but there are only a handful that actually allow for private enforcement. One of them, for example, is Washington. And so, to the extent you have operations in various states, just be mindful of what that potential risk could be like, and where you could see potential litigation on that front.
And it looks like, Michael, we've got a couple of questions that maybe we can hit quickly. So for the first one, what do you mean when you say best practices and attestation system?
Sure. So in California, there was a case called Donahue that came out from the Supreme Court that basically said it dealt with an issue of rounding of meal periods, and it held definitively that you cannot round employee meal periods at all. I don't think many employers in California were doing that to begin with, and we'll touch on rounding as it relates to compensable time a little bit later in the presentation. But one of the important things that came out from Donahue was that the court said that there is effectively now a rebuttable presumption of a meal period violation where the time punches on their face show that a meal period was not taken in a lawful manner. That can either be because a meal period was not recorded at all, it can be because a meal period was short, less than 30 minutes, or it can be that a meal period was late, meaning that it was not taken before the end of the 5th hour. And so that's a massive shift from what the case law was before, where the employee had to prove that there were these violations. Now, looking on the face of time records alone, a court could say, I see that there are all these violations, and now it's the defendant's burden to show that, no, we actually did provide those meal periods. There's no obligation to police them, but you have to at least provide evidence showing that across the board you did provide it. And so what's the best way of doing that? What can employers do to have a uniform system that allows them to rebut that presumption? And the Donahue court basically put a gold star on this attestation process where an employee every day will attest to or certify that they were provided with their required meal breaks and their required rest breaks. That can typically be done electronically. For example, there are clients that we have that on their timekeeping system, on their time punch clock, has a question that pops up every single day where the employee says, has to answer the question of, were you provided a meal period today in compliance with the company's policy, yes or no, same thing for a rest break. And then depending on how they answer that question, the employee will receive or will flag for the manager to approve a meal period or rest period premium to be issued. That type of evidence, that process has been held to be effectively the best type of system that an employer can have that rebuts against the presumption of a violation. And so having that type of system implemented, and we can certainly work with you on that if you have any questions, is something that everybody should consider, and ways to have that so that you're not looking at a case 3 years down the line and trying to figure out how do we prove that the employee did in fact get that break. I could talk about that for hours. I won't take up more of the time here, but I appreciate, John, that you flagging that so we can answer it right now.
Yeah, thanks. And I think that would be helpful under federal, the FLSA as well. I'm just going to hit the next two questions really quickly before we move on. So another question is, and Michael, I think this is for you. If an employee is meeting the standards for California rest breaks, but the employee has made an accommodation request for an additional rest break, let's say, for example, an additional 20 minutes, can that additional 20 minutes be non-compensated under state law?
Yeah, so I mean, we'd have to look into kind of the hardship analysis and things like that. Generally, with how I've had clients do it, is that they've treated it as being paid time anyways. I think it's the safer approach, and it's not really a situation that you want to run into where somebody says down the line it should have been paid and it wasn't. It really depends on how long the breaks are, how frequent, and what you're willing to do or not do. But that's something that we can definitely look into and look into the particular situation.
And then the first question, or I guess the third question, so I took them in reverse order, is if an employee approves their timesheet after they clock out for the day, is that time compensable? Let's say it's done every couple of weeks and it takes 15 to 30 seconds. I think under the FLSA, there may be a good de minimis argument here at the very least. But do you have any thoughts under state law, Michael?
Yeah, if this is something that the employee has to do, that they're required to do because the company mandates it or directs them to do it, then that's something that would fall under, the suffered or permitted to work, whether required to do so or not, or subject to control prongs under California law. And so arguably that time would be compensable. Then you get into, is it de minimis, right? And John, I agree with you, under the federal rules, that seems to be the very definition of de minimis. But under California, the Troster case basically puts out a standard of there still could be some amount of time that is non-compensable, whether it's, so irregular or brief in duration. The question then becomes, what's the scope of that definition, right? And there aren't any cases that really have delved into what that standard is. I would certainly take the position that if it's something that takes 10 seconds or 15 seconds and they do it once every 2 weeks, that should fall within the contours of the California de minimis rule, even whatever is left of it after Troster. But it's certainly something that, doesn't really, it would be better business sense to just kind of incorporate that time and pay for it because it is so small than to have to deal with defending it or, being subject to a claim for related penalties, which are always going to be significantly more expensive if you have to defend that down the road or if an employee complains about it. But it really, again, will come down to the factual questions of how long is it, how frequent is it. At the end of the day, if it's something that everybody has to do, the company knows that everybody is doing it, even if it is so irregular once every 2 weeks, that still could be deemed by a court to be something that you're on notice of and is going to be happening regularly and that it's potentially compensable.
Great. Let's can we go to the next slide? And then moving forward, okay, yeah, this is perfect. So this is an issue that comes up, and I think we have a question, which I'll take here in a second. And I think it sort of dovetails into this slide as well. So one difficulty that has come up and that I've seen in cases recently over the last couple of years is just the fact that employees are, sending emails, having phone calls, sending text messages, all these different things at home before their workday starts, after their workday ends, and they may be claiming that they're working off the clock or that they are required to do this work at home and they weren't permitted to track all of their time because the employer allegedly doesn't want to pay overtime, things along those natures. And so that is an issue that it is fact intensive. It's hard to get rid of that on summary judgment or on a motion to dismiss. But generally speaking, if the employer doesn't, the employer doesn't want somebody to be working, isn't a complete defense. If the employer permits an employee to work during that time and knows about it or has reason to know that an employee is doing that work, then it will be compensable time, even if the employer has also given an instruction that says, don't work after 5 p.m. or something along those lines. And so the factual question is going to be, has the employer permitted the employee to work? And does the employer know or have reason to believe that the employee is working? There can be the minimis considerations as well. And we'll talk, I know there's been a couple of questions about the definition of the minimis, and we'll have a slide on that in just a few minutes. I don't know, Michael or Kelly, if you have any thoughts on this. This is a difficult question that comes up, and it's a fact question, which makes it difficult to get rid of a case early on without hearing the merits on it.
Yeah, I mean, it's something that clients, frankly, are always asking about. I can think of one case that I had where, it's the client's asking, how much do we actually want to dig into these situations, right? Because the more you dig into it, the more you are aware and you're on notice of it. And the rules generally for, there's some good defenses in California that you're not required to pay out for time if you have no knowledge of it, and you should not be aware of that. But if you are in a particular situation where you have managers receiving emails from other employees And, what if it's sent at 5:30 and their shift ends at 5? Is a manager going to generally be aware of when that time is or when the employee was actually working for that day, such that they should be on notice that it's definitely off the clock time that should be compensated? How much does a manager have to actually investigate if they receive an email like that? Is it different if it's a situation where they're getting emails or work received at 10 p.m. at night when it's so clearly outside of what is generally like a regular work day, right? There are so many things to think about in that sense, and it's harder and harder now because when everybody worked from home and when there was that shift, you've just got people that for whatever reason moved home, whether because the workplace was shut down or it was more convenient, and there were more conveniences that were granted to them, being able to email from their phone where maybe they generally weren't able to, or just a general lack of boundaries that traditionally were in the workplace, right? And so someone might wake up and send an email or forget something and decide to do it late at night when they would otherwise leave it for the next day. And that's going to be tricky. There's no direct answer, I think, on how you do it. I think if you see issues like this popping up, you should absolutely reach out and have that discussion as to, do we do this investigation? Do we look into this? Do we treat this as compensable time or not? Do we discipline the employee? What do we do in these particular situations as we're managing a more modern workplace?
We can go to the next slide, and I want to try and get through a few, but then I do want to try and hit a couple of questions that we've had come in as well. But I know we're running low on time. So one question that comes up a lot is waiting time or on-call time. Basically, it's the question of is somebody engaged to wait versus are they waiting to be engaged? And if they're engaged to wait, they have to be paid. If they're waiting to be engaged, then it's non-compensable or non-compensable time. And courts generally ask, who is the time benefiting? Who's that wait time benefiting? Is the employee able to use that time effectively for their own purposes? In other words, can they drive? Are they stuck in one location? Do they have freedom of movement? Do they, can they engage in their own personal activities during that time? And there's some other factors here listed. And so that's an issue that comes up. Michael, any California considerations on that topic?
Yeah, I mean, the last two prongs there are the bullet points on callback pay and regular rate. So generally we've seen, you want to make sure that to the extent you are giving these employees the on-call or the standby pay, make sure that it's being factored in for purposes of overtime. To the extent you have employees that are showing up and they're only doing an hour or 2 hours of work, that there are still reporting time obligations in California that you have to comply with to make sure that you're paying them the minimum amounts for hours based on reporting for that day. You also have regular rate of pay implications, which in California, the regular rate of pay now bleeds into not just overtime considerations, but also premium payments for meal and rest breaks, also for sick pay, and even for reporting time pay. I've seen some employers who give employees who are on uncontrolled standby, right, where they're clearly doing their own stuff. They're not going to fall into the rule of, you are actually on call, but these employers nevertheless still give these employees like a daily stipend or something just because there is a potential that they might be on call. And, that's something that arguably has to be factored into the regular rate of pay, and that can be an easy way to be tripped up. It's also potentially a flat sum bonus, which has its own set of rules under California and the recent Alvarado case about how you treat flat sum bonuses for regular rate calculations as opposed to other types of compensation. So, these are all potential pitfalls to be aware of. Again, if anything like this pops up for your particular practice or your business, please keep that in mind and reach out if you have any additional questions on that.
So let's go to the next slide, please. And one more. And I just want to briefly talk about the minimus doctrines. I know we've mentioned it earlier, and we had at least a couple of questions on it, and then maybe we try and answer a couple of questions quickly if we have time. So there's not a particular. So the minimus doctrine is not specifically in the FLSA. It's not like there's a specific statute, but it's the Supreme Court recognized it years ago that just simple trifles of time aren't necessarily need to be compensated under the FLSA. And the courts have found time ranging from 1 minute to 20 minutes to be de minimis. I don't know that a court recently would go with the 20-minute time frame. I think that's pretty long. Probably 10 minutes or less, and preferably even just like a minute or two, and maybe even less than that would be more likely under the FLSA more recently. It can also be difficult to raise a de minimis defense even if it's a short amount of time, but it happens regularly or it happens daily. Courts have said, that time adds up over a 3-year statute of limitation period. It's a lot of time. And it's not necessarily the minimus if it regularly happens and the employer is just ignoring that time. So there's a few factors here listed that courts look at. So that's really what we're talking about when we're talking about the minimis doctrine, at least under the FLSA.
Yeah, and pointing to that, while that federal de minimis doctrine is dead in California, this is an area that I litigated for a long time while it was hot before the Troster decision came down, and there are a lot of things that you can do if you are facing these types of factual situations where maybe you have, if you're subject to the federal de minimis doctrine, but you still want to make sure you're able to defend yourself. There's video evidence that you can have. There's time and motion studies that can be done. There are different ways to gather that evidence to prove it. But even, as we see from the Cadena decision that came out yesterday, the second part of the case, if you're unable to show, across the board, and we're talking about, class actions here or collective actions, right? If you're unable to show that you can narrow it down or you can reach a consensus on what the actual amount of time is, if you have some employees that are going out there and saying, I have to spend 40 minutes a day doing some crazy task, it seems insane, but in our cases, we would have some employees who would testify under oath that, no, it took me 40 minutes to exit the store while I was undergoing a bag check because I had to wait for the manager and the manager was busy. And, you have to figure out ways to bring that number down so that, to John's point, it's well within that aggregate of leading up to 10 minutes. And when we look at the Cadena case from yesterday, courts are generally still towing that 10-minute line. But, if you've got some people here or there that are saying it took significantly more than that, that could create a tribal issue that's going to make it very hard for you to get some sort of summary judgment decision on that case. Moving to California, I mentioned a little bit earlier, but I'll reference it again. Again, Troster said that the federal de minimis rule does not apply in California. There is still some contour of the de minimis doctrine with the Troster decision. But again, what the contours of that are is really undeveloped, even though it's been 6 years since that case came out. It's not something that people generally are going to be litigating to the death to figure out where is the court drawing the line on the amount of time. But, if it's something that is so irregular or brief in duration that you could potentially make that argument, then it's something to consider. Another area where you can potentially consider the de minimis doctrine is the healthcare industry. So one weird nuanced quirk of the wage orders in California is that wage order 5, which covers healthcare workers in the healthcare industry, has in their definition of hours worked, it actually references and says it's governed by the FLSA definition of hours worked. And so arguably there could be an application of the Portal to Portal Act there and potentially the federal de minimis defense. It's not something that's been tested, but it's something that is a potentially creative argument that people can consider if they're dealing with these situations. And then finally, with rounding, that was one of the areas where you always saw the need to potentially pay compensable time, where if a court says, your rounding practice was not lawful and neutral in practice and in application, and that a few minutes here or there that were otherwise covered by rounding could potentially be paid time. Generally, we've seen courts start moving away from rounding, and it's on appeal right now. There's a bad decision that came out in the Kemp case in 2022. Review was granted, and now that's in front of the California Supreme Court. We anticipate that that decision is once and for all going to mandate whatever the standard is on rounding, and whether that can actually remain in place and with what limitations, or whether rounding will ultimately be deemed unlawful in whole. And so generally, if you do still have some rounding practices, we would urge you to reconsider those and to look at those and to just go directly to a minute-to-minute pay practice instead of having any sort of rounding.
So I know that we're at time, I believe, or maybe even over. So maybe let's go quickly because I want to get to the CLE, I think.
Yeah.
So we have a slide here on interns. Michael, maybe just 30 seconds on this or so.
Yeah, I'll do this very quickly, and then we can give the CLE and let everybody get out if you're on time. Interns might be something that you're dealing with as a business, and it doesn't pop up all that often. But quick, important notes to make on this: you're looking at what we call a primary beneficiary test. It's a test that came out of the Second Circuit, but California relies on this standard too, as do other jurisdictions. And generally, if you're following those 7 bullets that are on the screen, where you're making sure that there's no expectation of compensation, the training mirrors an educational environment, you're integrating some sort of coursework or academic credit, you're making sure to accommodate academic commitments instead of work, you've got a limited duration, you're not replacing other paid employees, you're not promising any employment. If you're doing those types of things, then generally you'll be okay with having a lawful internship without getting into a situation of particular compensable time. But also note that there could be state-specific requirements. New Hampshire, for example, has a requirement that any types of these internship programs have to be registered and approved by the labor commissioner, which could potentially be more helpful because then you'll at least know right off the bat whether you could be in hot water down the road or not. But otherwise, it's something to look for if you have particular state operations and you do have interns to make sure you're complying with those local requirements.
And then I know there's a few questions. Kelly, does it make sense to go to the CLE and then maybe we answer some questions afterwards?
I think so. So I'm going to give everybody a minute to grab their phones because we have this nifty new way of obtaining CLE through scanning that code that appears there, the QR code. So now that you have your phones, I'll tell you that the CLE code for this session is SS, as in Seyfarth Shaw, 7148, SS 7148. And apologies for going a few minutes over, but I see that very few people have dropped off the call, so I'm thinking that folks are finding this helpful. So if you want to return to the questions that were asked, John, folks can stay on or drop off as their day may require.
Great, thanks, Kelly. And Michael, not to put you on the spot, but I do think most of these questions appear to be geared towards you.
Yeah, I mean, I can look through them and answer a couple. I do have a hard stop, so I have to drop off in a little bit. But we can always, we do our best to the extent we don't get to it to follow up after the webinar. We'll get a list of all the questions and we'll make sure that we can address it. We have your information from the registration list. So if we don't get to it, then we can do it. One of the questions, I think we covered it, is on the de minimis test and the 10 minutes or less. I think that's easy enough that we did it. One of the tricky things that we're seeing, someone raise the question of remote and hybrid work, is, what are you doing if you have an employee that has to drive to the office in reasonable commuting distance for some meetings or company events? My general suggestion is that if this employee, I would look at where they started from. If you've got a particular situation where an employee started out as having to come into the office and commute, and then it delved into or morphed into a situation where they are actually doing some sort of hybrid structure instead, that because they had an expectation of that commuting distance, then that is part of their normal commute and not something to be compensated. But if you have the reverse situation where you had a remote employee and now you're bringing them into the work or not, it really depends on kind of what their expectation was of that job. And so, again, I know we keep using the same sounding points, but a lot of that will factor into what the particular factual situation is for that employee. And, what are we talking about? Oftentimes in California, the just doing the right thing, taking a more conservative approach and paying for these things initially, giving, mileage or reimbursement for that commute is generally going to, pay, it's going to be better off to do that now rather than to be in a situation where down the road someone claims, oh, I wasn't paid for this, and then you're going to incur attorney's fees. Generally, the value of what they're asking for in the pay is going to be significantly less than what it's going to cost to defend that down the road. So things like that. Another question that I see is kind of what are we dealing with if the time clock goes a little bit over a minute of what the actual time is? You need to pay based off of what the actual punches are. And so if the time clock is registering it as being that you worked, that you had an extra minute and that goes into overtime, then absolutely that has to be paid overtime. And that's one of those things that bleeds into not just overtime compensability, but also to the scheduling of meal and rest breaks. So, if you've got a meal period, for example, in California, has to be taken no later than the end of the 5th hour of work. And so that means if you're starting your shift at 7 a.m., you have to take your meal period before 12. What if an employee clocks in 1 minute early and then says, oh, it's 12 o'clock, I'm going to go take my lunch? Technically, that will be 1 minute late, and then you run into an issue with a potential Donahue issue of a rebuttable presumption of a violation. And so there are so many best practices that can be done. Schedule employees earlier, make sure that people are being mindful of what the times are, make sure that the actual clock is synced with the time clock so that there's not a situation where people are incurring potential extra time that you will otherwise still have to pay for, stuff like that.
Donna, can you flip back a screen or two? So thank you for joining us today. And as Michael said, we're happy to circle back on any questions that our presenters weren't able to answer today. But I hope you'll find the time well spent, so to speak, on listening to John and Michael today. And on the screen, you'll see information about the treatise that I mentioned earlier. And we just want to thank you again for joining us for this last session. And wanted to mention to you that the previous sessions of the Time Well Spent series, Donna, is there one that lists all the programs that we did? All of those prior programs are up on YouTube. I think you can get to them by just searching Seyfarth Shaw LLP and then finding the Time Well Spent seminars if you're so interested. So thank you again. And I just wanted to give a shout out to Donna and all of our other help in producing this series. And with that, we'll say good afternoon. Best wishes to everybody for a safe and happy summer.